Hold on. Hold on, everybody. We're going to call the meeting to order. Everybody. Please, thank you. Okay, I'm calling the meeting of the Rappahannock County Board of Zoning Appeals to order. This is our regular monthly meeting. The first item, well, actually would be to call the roll. Michelle Summers is here. She's our zoning administrator. Jennifer Matthews.
I'm here.
Alex Sharp, I'm here. David Connick.
Here.
And Chris Berg.
Present.
We are short one member because I don't think a member's been appointed yet to take Bill Anderson's place. So it's only the four of us. So the first item on the agenda is to adopt the agenda with or without changes.
Mr. Chairman, I'd like to make a change that we move review of the minutes to under old business, so put it to the after the public hearing.
Oh, that's why everybody's here.
For the minutes, we have them.
Yeah, there was a typo somewhere. Yeah. Is that agreeable with everybody? Is there any other changes? Okay.
I move it be adopted as amended.
Is there a second?
Second.
All in favor?
Aye.
Aye. Okay. The agenda is adopted. So the first item on the agenda of the public hearing is the Bell Tourist Home. Is there somebody here to represent the applicants? Would you come forward, please? And you can identify yourself.
I'm Susan Bell.
Okay. And please have a seat. And if you would like to, just tell us a little bit about
Alex, swear?
No, we're not.
We don't do that?
Not on the special use. Okay, go ahead and tell us what you're doing.
I have a property that is off of Route 637, which is North Coast Road. And it's 50 acres. I have a house that is 3 floors, and I'd like to have the bottom floor be available for to rent to people as an Airbnb.
Okay.
And answer any questions regarding that.
Okay. You're on the right of way.
I am.
What's the description of that? You know?
It's a 50-foot right-of-way.
Okay.
It's shared by 6 properties, 3 25 acres, 2 40 acres, I believe, and my 50-acre property. And I'm at the very end of that right-of-way.
Okay. Is it the planning commission had a recommendation?
They recommended to approve.
And they had some conditions they recommended.
Yeah, there are ones.
And
Do you want me to read those out loud? That only on the lowest level of the house, this is from the planning commission, owner must be on site when rented, a maximum of 6 people, maximum of 2 cars, and the safety features have to be installed. Working smoke detectors, carbon monoxide detectors, a working fire extinguisher, and emergency contact list to include the address of the rental, the sheriff's office phone number, and the owner's contact information and the permitted noise levels.
And was it anybody opposed?
No, sir.
So there was a letter from Dubois. That's not really opposed. Okay. Is there any questions from the board members?
I have a point that I'd like to ask. Is there anything like one of these fire pits where people put fire in it and then sit around?
Not a formal one. My children have had fire pits, they've had pig roasts, but nothing formal, no.
I would wonder if you would not want to add something about not any of these open fire pits, because we have had problems in other places where they thought that they were out in the woods and they could just do something and then they turn their backs and all of a sudden the fire was running.
I've got some questions.
Go ahead, David.
On this, on the page of this, did you draw that?
Yeah.
What does it mean where it says pig roast?
Well, that's an old map that was referring people to how to get to, we had an annual pig roast
I
at
see.
our property.
So that's not there.
And that's what, we had a fire pit there as well.
Okay, but I mean, so
I should have scratched that off of the
Okay.
map.
Or white out.
Yeah.
I just thought maybe they're going to.
No, it's not going to be advertised or used for that kind of purpose.
So you're, I want to ask you some questions about the right-of-way. What kind of a road is built on the right-of-way?
As I said, it's a 50-foot right-of-way that was established by the person that we acquired the property from. Rust, and it was Mary Cleverly's property, if any of you go back that far
I
in
know Mary
history.
Cleverly.
Did you buy your place from him?
No.
And she acquired the property, she and her husband, I think, owned the property. The right-of-way was established when she needed to build a bridge because Kutsevich, who owned the property adjacent to hers, was denying her access to her property. So we, in exchange for Tom Andrews building a bridge, she gave him 50 acres, which has now become our 50 acres, my 50 acres.
So I don't think you exactly answered my question. I mean, can two cars pass on the road?
Not at every point of the road, but there are pull-off areas, yes.
And is there, which I assume is just gravel, it's not paved, right?
No, it's not paved.
And so how wide is the paved part? I'm sorry, how wide is the improved part, the gravel part?
The gravel portion is, I'm only guessing, it's what is normally spread by a
So it's
truck.
like 8, 10 feet wide?
12,
Yeah.
10, 12.
10, 12 feet wide, yes.
And Michelle, do you know if all the neighbors on this road, I mean, not just the adjoining ones, but has everybody on the road been notified?
There were 2 speakers at the planning commission that also accessed the road, and they didn't have any opposition to this proposal.
And how many did you say there are altogether?
Well, there are a number of parcels, but the ownership of all of the parcels is me, Jim Warwick, and Helen DuBois.
Jim Warwick?
Jim Warwick,
And
yes.
who's the other?
Helen
So
DuBois.
those 3 people own all the lots, and there's
Yes.
6 lots, but it's only really
Correct.
3 people.
Yeah.
So if 2 of them came.
Well, Mr. Warwick was present, and I believe another lady was in the audience.
Yeah.
Okay, so they know about it.
Yes, absolutely, yes.
Chris, do you have any, or you done?
But the only other question I had was, these things, these conditions that were up there,
Yes.
I mean, is that all done? Or is that stuff you're gonna have to do?
No, that's all accomplished. The smoke detectors, that's all done.
And are you gonna be there when guests are there?
Yes,
So it's not gonna be like the house, you're gonna give them the key and say, see you next month?
that's right, yes.
And how long do you anticipate people are gonna stay there?
Oh, perhaps a weekend? Does that matter to you?
I think he's just asking.
Well,
I
we've
mean,
had some.
is it a condition?
No.
I'm just a member, I'm just asking questions. That's all I have to.
Do you have any questions, Chris?
I don't
notice on the Dubois letter, they made a couple of requests. Have you seen their letter?
I have.
Did you have any reaction to that?
Well, I had several meetings with the Dubois. They were very amicable to what I was doing, and I was very surprised that they wrote a letter with conditions to the board.
So do you have any reaction to those requests?
I've told them that as I always have, I'm helping to maintain the road. No problem with any of their conditions.
Because they're suggesting, you're present, not allowing them to engage in hunting or shooting.
I don't have a problem with that.
Okay,
And would you, as a board, have a problem with that?
with hunting,
Yeah.
not necessarily.
That's the one, huh?
No, I'm just inquiring.
Well,
Okay.
I mean, everybody who has gun needs to be responsible, and you just can't go out and start shooting up in the air and going woo-hoo and stuff like that, because bullets will fall someplace.
The other request they made was that it be issued to the owner, not the parcel.
Yeah, but that's not.
Do you have a problem with that, that if you sell the property, that the special use permit would terminate?
I don't have a problem with that, but that's not normally a condition.
Sometimes it is.
Is it?
Can be.
And after reading that, there's one other thing, is there is no road maintenance agreement?
There is a road maintenance agreement, but I am not part of that road maintenance agreement as a legal condition.
Why not? I mean, just out of curiosity.
Well, because Tom Andrews, who built the road, and then we who rebuilt the road and have maintained the road, specifically didn't want to be embroiled in a maintenance agreement with other property owners. And,
So you're maintaining it?
well, we with the Du Bois are maintaining it, but it's not a legal binding agreement.
Okay. I guess, is that all the questions? Michelle, would you have anything to add?
Michelle, have you been out there and seen this road?
No, I have not.
I'm going to open the public hearing on this application. This is just to speak about this application, is it?
Not about
These are all people that are in favor.
Oh, they're all in favor. Okay. Okay, so by the applause meter, we go. Okay, is there anybody here who would like to speak on this application?
Yes, I'm Jim Warwick. I own 6/10 of a mile of the right-of-way that crosses my property. And as I said at the Planning Commission meeting, I have no objection to this. And the maintenance is taken care of by all the owners of the properties involved has not been a problem for the last many years. So it's that even though it may be slightly untidy as far as who has a written obligation to do what, there's never been a problem. In fact, recently, the Dubois and Susan were involved in putting some gravel down in some places that could use it. So the maintenance is not an issue. As far as the width and passing, there's one area that's a kind of an uphill S-turn where there's not really room for two cars. That's a very small area of the 1 mile or so. So that really, being able to get in a situation you can't pass is not a problem, except maybe on a very rare occasion when people should be going slowly and seeing each other anyway.
Okay, thank you. Is there anybody else? Okay, I'm going to close the public hearing. Do we have a motion?
I'd like to make a motion that we approve this as the Planning Commission with the stipulations of the Planning Commission, and add the fact that there should be regulation of fire I know you're gonna be on site, but they're written for the safety features, that they're not to go out and start burning, making a fire pit or something like that, and we have to go down and never come back. We're doing marshmallows and s'mores or something like that, so like that, fire pit, open fires.
Okay. I'm not sure if I agree with the fire pit. Is there a second to that motion?
I will second that.
Okay. Is there any further discussion?
Well, I'm just going to say that I think that with the right-of-way like that, I think we ought to continue it for 30 days and ask the zoning administrator to go out there and see if the road meets the standards of the subdivision ordinance, which is what is proposed for these B&Bs and so forth on that are not on public roads. Because it may be all right now, but it may not be. And plus, it's not fair to treat one different than others. So we've had this problem with Harmony, what's it called? Manor, yeah, Harmony Manor, and went to court and so forth, that the board approved. That was a right-of-way that was less, but the current proposal is not to talk about the right-of-way. The right-of-way just is a 50-foot kind of area in which you could build the road. And as we heard, the road's now 50 feet, the road's 10 or 12 feet. And I think we ought to stick to this, to the standard. So that's what I would say. If you're not going to do that, and I didn't hear if you put in your motion to terminate when she sells it.
Yeah, that was the conditions that
Is that in there?
That's not the planning commission. I would
on
think.
planning commission, well, only to the owner,
So it's personal?
personal to her. I thought that was,
I don't know, that motion.
I mean, you would
Yeah.
add that.
I would have to, yeah.
Well, that's my motion, to continue it, and then
Permit to
let them inspect the road and see if it meets the...
So wait, we had a motion and a second.
Right, so I'm offering an amendment or a motion to continue it. To
Which
table
is-
it, I guess, to table it, so that take... I don't
Which
know.
is different from the motion and the
No, my
second.
motion is to table it until that can be verified.
Is there a second to that motion? Okay, we're not gonna follow through on that one, I guess.
Guess not.
Okay, on the other one, it's been made and seconded, I think we've discussed it. All in favor?
Aye.
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 Abstain.
Okay,
It's
thank you.
approved.
It's approved.
Thank you.
With those conditions.
Did we have another one? Okay. All right, I think we're doing the minutes. Okay, the next item on the agenda is 15 Main Street, and it's a request for a variance from the maximum permitted area of a sign from 75 square feet. It's a welcome to Sperryville sign, and the requested area is 285 square feet. It's on the side of the building. Before we actually bring this up, I know there's a lot of people here about this application, so I just wanted to make a couple of statements. And I think we did get several letters, emails, phone calls, etc., about what a beautiful sign it is and what wonderful things it'll do for Sperryville, which I actually find myself agreeing with. And I think that potentially the other members of the board would agree with that as well. I think the issue, though, that the Board of Zoning Appeals, we deal with applications that are brought before us, and we're typically dealing with the zoning ordinance as it is written. And we have a certain, we're sort of a relief valve for anything that's unfair in the ordinance or would unreasonably restrict someone. we're not an architectural review board, and we're not a business development group. So even though this probably fills every possible need of those groups, what we have to deal with, and if you read the law about variances, that there's a certain amount of hardship that needs to be proven, and there is a question as to whether we can even grant a variance for a sign. And I would just say to you is, I don't see where in your application you have dealt with hardship and to show that there's a hardship. And we have a couple of areas that we have to follow. One of them is you need to show substantial hardship, not an inconvenience. But the other thing is this situation should not be shared or common to other properties in your area, your district, or the area. And so I personally would not see how you could say your property is different, because every building has a wall on it, for example. So there's a couple of short areas where I think your application is short of what you might need to actually get a chance at getting approval. The other thing is we're a member short. You would require 3 votes of this group. Now, the other thing I did want to say to everybody, and I better say it before I speak too much more, but I do have a business relationship with Mr. Chapman, and I got an opinion that does not require me to recuse myself, but I am disclosing that I rent some space to him. So, but basically, I think, I'm not speaking for them necessarily, but I feel like the board would probably I guess not open this and give you till next month to address those couple of concerns if you think you can, rather than having it heard tonight, because I think, I would just say, predict that it's unlikely to pass tonight as it is submitted.
Come on.
May I address the board? Is this a,
yeah, go ahead.
First of all,
yeah,
could you say your name?
yeah, sure. I mean, I have remarks prepared. If the board would indulge me, I'd like to stand.
Well, are we opening it or?
I don't know.
Okay.
I don't know.
Oh, he's the applicant. Go ahead and introduce yourself.
So, good evening. My name is Robert Chapman. My friends call me Robert Archer. I'm a resident of Sperryville, full-time Piedmont district. And in your capacity to make judgments on zoning and ordinances, I would ask you to take my remarks into consideration, exclusive of this application. So I come before you this evening on instruction from the zoning office seeking a variance for the Welcome to Sperryville, quote-unquote, sign at 15 Main Street. But tonight I wish to speak to you about intent. My intent in painting the wall on the side of my building, and the original intent of our signage ordinance. My intent in painting the wall was purely good-spirited, and in its creation I believed would become an asset to our village. Prior to its painting, I consulted neighbors and Main Street businesses and found there to be wide support for the design. I believe my intent mirrored the original intent of the Rappahannock ordinances, and that is to enhance the attractiveness of Rappahannock County. The wall has had a positive effect on local morale. Countless emails applauding the artistic merits, nostalgic styling, and references to Rappahannock's agrarian past have flooded my inbox. Countless passers-by stopping to take pictures, get out, say hello, and walk to the end of Main Street just to take a selfie with the wall have been a daily occurrence. What was once a nondescript building wall at the entrance to Sperryville is now a point of pride for the community. over 550 signatures in person and online, coupled with the people before you here this evening, standing in unity and advocacy, speak to the desire of our neighbors. There is a reason the signage ordinance clarifies sign size by zoning type. A particular sign type that is appropriate for one area may not be appropriate for another. Village commercial signs max out at 75 square feet. General commercial signs max out at 150 square feet. This differentiation points to the original intent of the code, which is to limit making things known. Signs make things known. The signage ordinance reads, any writing, letter, or numeral work, pictorial presentation, illustration, decoration, emblem, device, symbol, trade, flag mark, banner, pennant, sculpture, any other device, figure, or similar character, which is used to announce, direct attention, to identify, advertise, or otherwise make things known. I argue that what I've painted on my building does not make anything known. It does not advertise my business. It does not give direction. It does not tell a story. It does not give any clue to what lies inside the building, nor make anything known. Its markings do not fall under the interpretation of the signage ordinance. It is not a sign. Put differently, what is this wall currently making known? Had I painted the word hello on the wall, would this also be considered a sign? The answer is no. It doesn't make anything known. Therefore, I hereby request you take into consideration the intent in which I painted my building, the overwhelming support of our neighbors, and the original intent of the signage ordinance. I ask you to overturn the zoning office's findings and deem my painted wall definitively not a sign. Thank you for listening to my remarks. If I further indulge, I'd like to read some comments from neighbors.
Could we just hold on for a second? There was one thing that I neglected to say. Since this is generally shared by basically all properties in the county, and there is a sign ordinance, and the supervisors do engage in text amendments to the ordinance, really the correct way to do this would be to go to the Board of Supervisors, get an amendment to the ordinance that addresses your situation, and then it can apply to others. And so, because I have observed, and I mean, I haven't been that aware of signs before, but going up and down the road, I'm sure there are a bunch of signs that nobody ever got a permit for.
So why does this one do that?
That's a good question. We're here, it's brought to us. I don't know. I wish I had the answer. But there are also, I've noticed a couple of other signs that are kind of on deck, huge signs that I guess will suddenly appear. And then I guess we'll be requesting, a variance will be requested of us in that one as well. And so if we start granting variances just for the convenience, then that may not be fair to others. So I think truly the correct way is to go, and if the supervisors find a way to modify the ordinance, which they do all the time, and make the case there, I think it's really, would be the correct way to go.
Just a second. Mr. Chairman, I think we should decide, are we going to hear this tonight, and does he want the time to fix up his application or not? Because that's the threshold issue. If Mr. what is it? It's not our Chapman, I'm sorry. If Mr. Chapman wants the time and wants to amend or supplement his application, that's the question we asked him, which he really didn't answer in his remarks. So I'm going to ask him again to answer that question. Because, and I just want to say, not only for you, but also to the people who are here who may be, unaware of the limitations that this board has. We don't make the law, we're stuck with what the supervisors give us. And not only that, we're stuck with what the state code says are the limitations of our authority. And it's very, very specific. And we have to make certain findings of fact before we can give a variance, because otherwise we'd be making new laws. And we're not a legislative body. We just have the authority to give a variance when 4 specific conditions are met. And you've heard some of them from Mr. Sharp. So the question is, as I understand it, what the chairman asked you is that your application doesn't address any of those 4 things. And my question again is, just like he asked, do you want the extra time to supplement or amend your application?
Sure. Well, up on, just for everybody's information, up there on the screen, there's, I guess it's section I or 1.
J.
Okay, whatever. Okay. No such variance shall be authorized except on finding by 3 of the members the following, and there are 4 conditions. And so if you would be able to look at that and address those, I don't feel like you've addressed them in your application.
So I am not able to address those nor answer your questions because as I understand the zoning ordinances, this board does not, the variance process does not speak to signage. So I feel like this application, the way I was directed, was erroneously brought to your plate.
Could be. But,
So I don't see how you can vote on this tonight, to be honest.
well,
You don't see what?
How you can vote up or down on this tonight.
also what we could do is we could continue it, or I don't know what the proper term is, but continue it till next month. But you would need to look at those to see how you could persuade us that we can make those findings. And I think that's a pretty high hurdle for you to close.
Well, whether it's a high hurdle or a low hurdle, it's up to him to put the evidence and put it on. And I think in fairness to the board members and in fairness to the people who want to speak, in fairness to the people who want to speak, I mean, you've got rights and they've got rights. And one of the rights is to know what it is, or what the basis is for what you're requesting the board to do. And I can tell you, I don't know, because it's not in the application. And what they just read is part of it, but if you look at section 170, 136J, it says every application has to have a statement that addresses those 4 points. And your statement that you read and your statement that you filed doesn't address any of them, much less all of them. And I'm just going to read you briefly, because it's very short, from a Supreme Court case that says the following: the threshold question for the BZA in considering an application for a variance, as well as for a court reviewing its decision, is whether the effect of the zoning ordinance upon the property under consideration as it stands interferes with all reasonable beneficial uses of the property taken as a whole. If the answer is in the negative, the BZA has no authority to go further. And that's Cochran versus Fairfax County Board of Zoning Appeals, a 2004 case. And so that's the law, and that's why I'm telling you, I mean, whether we love your sign, or love you, or love Sperryville, or think it's the most beautiful thing we ever saw in our life, doesn't matter. If we can't answer that question, yes, we can't give a variance. And so it's not, in other words, you have to address that issue. Because that's really the only issue that justifies this board to give a variance. So my recommendation to you, if you allow me, my recommendation is you should amend it. Take the month and amend it. and if you can do it, great. But that's what we're stuck with.
I do not want to withdraw my application.
I didn't suggest that.
I'm telling you. I would rather not kick this down the road because I cannot answer those 4 questions. And you do not have the authority, as I understand it, to make any decision on this.
So if we turned you down tonight, you cannot resubmit this for 1 year.
As member, right, but as member Connick just read, you cannot make a decision on this.
No, we can make a decision, but that, it's
No,
going to be a kind of dictated decision.
You're asking for a variance that I don't think we can grant.
We have the authority to do it,
To grant a variance?
to grant or deny.
But tonight, I don't think we
You
can.
have the authority to grant a signage variance?
Yeah, it's a
do?
concept.
Well, that's another issue.
You
I don't
do?
know, I mean,
This doesn't make sense.
We'll all show up as a board.
Seriously. I'll explain why.
what's the point?
My point of order is that this whole proceeding is based on this assumption made by the zoning administrator, and I think Mr. Archer is trying to address that there is a violation. You talked about a finding of fact, I think. The fact has not, so I understand, been found. And the question is, if there is to be here's a procedural question, what does it take, and what procedure is it to actually contest the idea that this is a violation
That's an
of
appeal.
a sign?
That's an appeal.
Are you, I don't understand your question, are you asking to contest whether or not the zoning administrator was correct or not correct when she said it's a sign?
Yes, right.
Well, at that time for that, he had to do that within 30 days of when she sent him the letter. And this, well, that's another issue, I'm glad you brought it up, because tonight, we only have one issue before us. And that issue is, is there a hardship that justifies getting a variance? We don't have an appeal in front of us of her decision. Nobody appealed it. And you have 30 days to appeal it from when it comes out. So if if the applicant wanted to appeal it, I think he had to file an appeal, not a variance request. And if he wants, I don't know, so that's a different issue. And all this business that he actually addressed already is my way of thinking, is really not relevant to the question that's on the table tonight. In other words, whether it's a sign or not. He's applied for a variance, and it says in his own application, it's a sign. I don't know if you've seen it, but he could have put it up there,
He can
Michelle.
amend the application.
Well, he could have, if it's a variance thing, look, I'm not gonna start giving him legal advice, but you're a lawyer, you give him legal advice. I'm just telling you that it's not an appeal that's on the table tonight. And the issue of whether the zoning administrator correctly or incorrectly decided it's a sign is not before us. If it was, well then, and you could have, it's possible to have like a dual application of, I suppose, you could have appealed that determination and coupled it with a variance if the answer is that the appeal is denied, but that's not what's before us. The only thing that's before us is the request for a variance, in which, right there, it says sign. The Sperryville spelled wrong, sign. I didn't write that. Is that your handwriting, Mr. Crawford?
Yeah.
Okay, I didn't write it, Mr. Goodman, he wrote it.
We've got it.
And there's a picture and there's various other things in there that say sign, sign, sign. So if you wanted to contest that it's not a sign, you should have appealed it.
Okay.
And again, we're limited to what we'll get.
So,
All right, so
would you like,
we can table this for
for a month?
for 30 days?
Well, it's till the next meeting.
Is that what you're requesting?
We could just table it till our next regular meeting.
I continue the hearing.
Continue the
We'll
hearing.
get to that. Is that what you want us to do?
Say yes.
Yes.
Okay, now.
All right.
There are a lot of people here who I'm sure want to speak. Is that correct? Okay, no.
Well, I don't think we should, again, if that's what we're going to do, I don't think that we should have a public hearing tonight, because I mean, you know, it's not for us to guess, except for the 4 or 5 people who are out there that have Welcome to Sperryville shirts on, who's going to say what. But everybody's entitled to comment on whatever they want to say, but the relevant issue is there a hardship or not? So for everybody to get up and comment on that when the applicant himself hasn't said what it is he's claiming, I don't think that would be an appropriate thing to do. So I think if we're going to continue it, we have to continue the whole thing. And I will so move. Continue the public hearing and table the application till next month, and give the applicant leave to supplement it or amend it during that time.
Is there a second?
I second that.
Is there any discussion on that? Okay, all in favor?
Aye.
Aye.
Okay, so that's unanimous. Okay,
Now,
so
I've got another issue.
Hold on, I was just going to before we. All right. Now, just to open this just a little bit, I know this is not what we were expecting, but is it someone who has something to add that hasn't been already said?
I don't think we should do. We just said we're continuing it.
I'm fine with people here.
I'd like to ask, what is the acceptable hardship?
Well,
Acceptable hardship is that he couldn't run his business. The house, the building would fall down or something
well,
like
so
that.
he couldn't reasonably use the property. This would be the main thing. So, like, for example, I think that property was probably too close to the road maybe, or, you know, if he was applying for a variance from the setback requirement, something like that, he could say, well, I can't use my property, or something like that.
That's the usual
That's the more,
basis for a variance.
that's the more typical one. It's typically a physical aspect of the property.
That would make more sense if it was actual advertising, which it is not.
Well, it's advertised in Sperryville.
You know, there's a sign on the highway that everybody has seen going up to Skyline Drive. It's a great big billboard, and it's bright orange, and it has Cooter's face on it.
But that's it.
Well,
How did that get approved?
I don't know that it did get approved. We don't know. That's not before us tonight. And if you have a problem with it, go talk to the zoning administrator and see where their permit is for it.
Well, I think it's relevant.
Okay, well, I think that's fine, probably for the public hearing. So come back next month. If,
I have some other thing I want to bring up,
oh, go ahead.
which I guess the applicant himself, I don't know if he brought it up or not. But there's a case that suggests what he says, you cannot grant a variance for a sign or a billboard. And I think we ought to get a legal opinion from the county attorney or whoever the board wants to get it from about whether or not that's even a doable thing.
A variance for a sign.
Right. There's a case, I think Adams Outdoor Advertising is down in Virginia Beach, and they had a limitation on how much you could spend on the sign. And they applied for a variance to exceed that limit, and the trial court and Supreme Court both said that you can't do it because the Board of Zoning Appeals can only grant variances from, quote, those provisions regulating the size or area of a lot or parcel of land, so it isn't that, or the size, area, bulk, or location of a building or structure. And it's not that. Or arguably it's not that, and that's the legal question. Those are the only things that you can get a variance for. And since the building's already there, and it's a non-conforming building, but it's already there, and he's not asking for a variance to make the building bigger or anything like that. The question is whether or not we even have jurisdiction or authority, because it's not related.
Okay, hold on.
Nothing? This is not related to the size, area, bulk, or location of a building or a structure. And so I think we ought to get a legal opinion of that, because, you know, I don't think we have to waste our time or his if the answer is no.
Okay, why don't we have a motion to seek that legal opinion?
Also move.
Is there a second?
Second.
Okay, is there any further discussion? All in favor?
Aye.
Aye.
Okay, so we're going to seek a legal opinion to that point, and hopefully we can have it within the next couple of weeks. And we'll let you know. Okay. Thank you, everybody, for coming. Okay, so what's the next item?
So, if it's going to be continued to next week, but you don't have a legal opinion,
Come back.
next month, I mean, you need the legal opinion before you can do anything, is that correct?
Yeah. Well, we're going to give that.
Okay, and that's, you need to have some timetable here that makes some sense. You can't give a legal opinion. And then everyone has to decide whether or not you go along. You know,
Thank you. Oh, okay, we're back after the recess. Okay, shall we do this arrangement? Would you like?
In June of 2016.
Okay, so what we had requested was an update from
Yes.
him.
And I have updated information. The permit was issued on the 22nd of June 2016. So the 2-year deadline runs up in 29 days.
2 years.
I have a rule on that, try to never do that in public.
Not very good.
Inspection sheet on the screen.
Yes, that is the last inspection sheet for the
And that was a couple days ago, 10/10, correct?
that was
May 10th, 2018.
All right, so
Yes.
it was, that's what I remember seeing.
So that's like within the last week? Or two?
Yeah.
Okay.
2 weeks.
Okay, 2
Don't do math in public.
Don't make my mistake. However, when the newspaper article came out, I did go to all the offices to make sure everybody had their paperwork. There was a piece of paper missing from the documentation that was turned over to the health department, which has since been rectified. A copy was also turned into.
Quick question, quick
Yes, sir,
question.
yes, sir, yes, sir.
And what is that, just for the electric service?
That is for the electric company to hook up, which was actually supposed to be done that same week. However, because of the storms, it's been pushed out for another 2 to 3 weeks for the hookup. However, the conduit is in place, and I do have pictures to show.
So you have the electrical is all done?
Yes.
It's approved, ready for the power company to hook up.
And the electric
Okay.
company also approved it on their end, and the conduit and probing was approved.
Sorry, it needs to want to come about.
I'm paying for it as I go. And I'm paying for everything. So, this is one of the pictures of the conduit. It's approximately 251 feet from the transformer pole to the dwelling. The meter base is on the dwelling. It has been there since 2016. The septic system was put into place, and that was one of the papers that was missing. The application was turned in, and the gentleman who put it in turned over all the paperwork in November 14th, 2017. But however, when he did the paperwork,
We have the completion
he
statement.
forgot to, I have my copy too, he forgot to sign this particular document.
So this is
So-
the
William
completion.
Green,
Yes, William Green. He goes by Billy. He's a very nice gentleman. He would have had the septic system put in prior to November of 2017, but he had an ankle replacement and a double knee surgery, so I had to wait 8 months for him. Which,
So what about the actual structure?
everything's done except for the skirting and the electric. So once the skirting is done and the electric company has hooked up, it will be ready for its final inspection.
Okay.
so,
By the building official.
Yes, sir?
so because of the storms, which are continuous,
Yes.
so you're maybe looking at July-ish?
No, 2 to 3 weeks from yesterday, so it would still be in June, and the electric company does know that there is a hookup deadline, which is why they're hoping to get it done sooner, since I paid and did the conduit and broke myself.
Okay, so yours moving forward, okay.
Yes.
Now there is the possibility of an extension if it's needed, correct?
Mhm.
So,
Well, if-
but you
I
need
think-
any extra time?
Well, it only says that you have to make substantial progress. It doesn't say you have to finish.
Oh, okay.
That was the other thing. I did paperwork with the county in regards to the taxes, because in 2016, 2017, it was taxed as personal property. However, starting this year, it's going to be residential. They deemed it in January,
You're talking about the
18.
trailer itself?
yes, 80% done as a family dwelling. And that was in January.
No, I don't think I
Does it-
think that the ordinance says that you have to, within 1 year, make substantial progress or start it. It doesn't say you have to finish it. Actually, there's no deadline on when you have to finish it. So
Oh,
she's making substantial progress, which it sounds like she
So-
is.
So
All you
we're
have to
probably
do is,
having-
well, I want you to notify, I guess, I don't know, maybe she's in the same office as the building official.
I'll know.
So when the certificate of occupancy is, granted, just send it to the board, I
You got a
guess.
copy?
I do not have a copy of that
No.
yet,
You
or
don't
the
have it
health
yet.
department.
Well, they won't.
You won't have that yet.
Okay,
Once that is issued,
Once
I'll
that's
provide a
done,
copy to
then
them.
just make sure you get it to Michelle, and she'll make sure to put it in the file of this file of yours.
I think.
Is that
That'd
your
be
room on
useful.
back in the back?
no, no, I was like, what did she?
It's similar.
Okay, so
She's
that,
home with a bug.
there's nothing else we
On
need.
legislative.
Nope.
I'm thinking this isn't a
Several
public
buttons.
hearing.
Oh, no.
No, okay. I mean, it's a public hearing without input. Okay.
Okay, thank you for coming in.
Thank
We
you.
appreciate it. Good luck with, I mean, we've been through several calamities, let's hope there's no more.
Oh, that is one thing I have a question for. If there is another setback from the electric company, do I need to reapply and?
No. I think we've established that just continue forward and you're
But
fine.
if there is a problem, you just let Michelle know,
Right.
Okay,
so she knows.
yes, because they told me 3 to 5 weeks, and then he called me yesterday and he goes, nope, I think I can get you in 2 to 3,
Okay,
which sounds a lot better
you're
than
fine.
5.
Just, thank you.
Thank you all so much. Have a
Thank you for
wonderful
coming.
evening.
Thank you.
What's next?
Come on, the Celtic game starts in 30 minutes.
What?
The Celtics game starts in 30 minutes.
Well, the Capitals game, it's
Hockey, yeah.
hockey, the Capitals start.
What sport is that?
Hockey?
Doesn't the ice melt? Is how warm it is?
There's the annual report.
I thought we finished the annual.
Well, we did, but it's on here for some reason. I guess because it's the final
I
version.
move that we approve it as amended.
Is there a second?
Second.
All in favor?
Time.
Aye.
No, I read it.
That goes to the Board of Supervisors as well. I guess my only question was, what are we going to do with one of these other agenda items that we talked about at our May 10th meeting, which is, are we going to put that on as a recommendation of the annual report.
Put what on us?
What we talked about the B and B definitions,
Oh, I think-
whatever it is we
I
finally
think
do.
we should, and I think we should
you
also
wanna
be getting
hold it?
that.
Well, do you want to have another little working session?
Well, I think we should, unless it was on tonight.
Do you think we should?
Yeah.
Okay, because that would probably be the best.
All right. Well, you want me to find out what's good for everybody?
What did we do last time, Thursday?
Thursday, but the third.
Something about the,
Because I think Jennifer couldn't make it the other day. Thursday is a court day sometimes for J&E court. So sometimes that's problematic because they always say the same thing. Well, court's usually over at like 2 o'clock, but sometimes they have some big contested hearing that goes on till 4 or 5 and you can't
So we
guarantee.
just have an alternative one.
You could have it at the library again if that's what you want to do.
no, I was okay for Wednesday. I think it was because of the court thing. Because we had it on the 10th, didn't we?
No,
Yeah,
it's because
Thursday.
I was out of town.
Yeah, right, we were down.
Yeah, we had it on the 10th.
If we have it on a Wednesday, I don't think there's any court on Wednesdays of either court. So that we could use this room.
So do you want to do, that's a Wednesday?
Yeah, well, what Wednesday do you want to do it?
Do we have to, we don't have to advertise it, do we?
We just have to put out the notices. And then
So-
continue the meeting.
Do we have
How
Chris
long is-
next week or the week after?
3 days.
Does it-
Well, if it's a continued meeting,
Next
we
week
got
would
plenty
be
of time.
fine with me.
Did that be the
Do
30th?
you want to do next week or the week after?
Let's get it done, because then we'll have something done before the planning commission meeting
Well,
next month.
What about, like,
What time?
can we do it in the morning?
Suits me.
Yep.
Yep.
Fine.
The horse is
10
okay with
o'clock?
that?
9 o'clock?
And where are we talking about?
Here,
Here in the courthouse?
yeah.
In the
Assuming
courtroom?
that it's
Okay.
available.
And let's say if it's not here, we'll have it at the
At the
library.
library.
Okay.
Fine.
All
I'll
right,
find that out.
so that is at 9?
9 or 10?
10.
10 a.m. on the 30th.
Fine.
It's Kennedy's birthday.
Okay.
Josh?
Cool.
Within
Bring the
101.
Okay, so do we move to, what are we doing, continuing this meeting
Yeah.
till the 30th?
What about the minutes?
Well, what about the minutes?
All these people are waiting to see what the typo was.
Oh,
It's the
okay.
riveting moments, you know?
I want to know too. I made another typo. I spelled drafter. I never did that again.
It's not Dr. Fat. Did we discuss a thank you to Bill
Oh, Bill
Anderson?
Anderson. Oh, we did.
Oh, I was gonna do that, so I'll bring it to the next meeting, the continued meeting. I meant to do it. I was just
I
gonna.
thought we had, but then
And then- No, we
So
decided
what
we
do we
would do.
do, like a resolution?
Yeah, a resolution.
I think that was
Do you know when he got it?
I'll find out from Peggy. And then we'll get them the usual gold label.
my name is spelled with 2 T's.
Where's that? Where do you see that? Is that
Sometimes
wrong
I
or
saw, I
right?
don't know if it was in this
Yeah,
one.
it's wrong.
Well, how many keys are there?
1, 2.
Here. It's 2 T's, but on the top of the
Oh,
second.
I'm sorry.
It's on top of the second page.
I've
Sorry.
been doing it for
That
that
way
for months.
It's 2 T's. It's 2
Okay,
T's.
on the top of the.
Wait, I can't find my
Right
April.
here.
Turn it over.
Yeah, but look at the roll call, it's that way there too, I've been copying
No,
that.
it's,
all
no,
the time.
it's 2
that's
T's, it's
two-
correct.
But.
Oh.
So add a T.
And sometimes
I'm sorry,
automatic
wait, I don't even have
spell,
this.
spell check switches
Oh,
it.
does it?
I thought I left a copy this.
No, you did, but I
Okay.
just lost it. Okay, so we got Matthews there, so we put Matthews here, and put on 2 T's. Okay, next, that's it? That's all you can
That's all.
find? Any other like substantive changes? I'm really getting good at this.
But so we did not, is it correct, we did not have minutes from the 10th?
Correct. I'll try to get
Just
them.
maybe, just a very brief thing.
A brief thing, there'll be minutes, not hours, like the board of supervisors does.
Okay.
They have 35 pages.
What do we have on for the June meeting?
Nothing on
Is there, other than
You know-
what would continue, is there anything on for the June meeting, any
Tomorrow.
pending things?
The planning commission had 2 things, but they're going to go to public hearing on it.
And then I'm gonna bring them to public hearing the following year.
So it's going to be July before they get to us.
Actually, it's gonna be June.
It is?
Mm-hmm.
Oh, they are going to have a public hearing.
They've already reviewed them and
Oh, so they're gonna have, right, so they're gonna do it, and then we're gonna have it right away.
Yeah.
Okay.
Is that what
Good enough. Well, since Mr. Curry's here, that's a fine time to bring that up. You know, we've had, well, I don't know if you're all aware of it, Chris certainly is aware of it, but suddenly someone read, you know, made the horrible mistake of reading what's actually printed in the zoning ordinance, which is always dangerous. And what is it, 170 something or another, 55, which is one of the things, sections that I proposed to amend in that package of amendments. It actually says that the planning commission is supposed to review things and then decide if it wants to have a public hearing on it. And so now, to my shock and amazement, at last month's planning commission meeting, they had 2 tourist homes, and even though we're trying to like streamline and expedite it, they reviewed everything and then voted to have a public hearing this coming June. So now they're going to have 2 meetings about every application, one to preliminarily review it, and one to actually have the public hearing, and then send it to us, which made some people, I heard, rather unhappy. Not only, and not just the applicants, but some of the members of the planning commission. In my view, I'll have to
You cannot have red tape if you do it in an expedited manner.
Yeah, right. What do you know about it? You're only on that.
I used to have to go down to Fairfax.
Oh, right.
I know how they do it down
Well, that's what I say. Whatever they do, I usually say in Lorraine, whatever they do in Page County, make sure we don't do it that way.
But so,
But my point is this. The way I read it. What?
Really?
About zoning, yeah. Well, that's why we got you over here. Don't put that in there. Anyway, what my view of it is, on special use and special permit I don't know about special exceptions that go to the Board of Supervisors, but my view, if you read the statute, it has hearing in the singular. And it says these things are supposed to be sent, first of all, they come to the zoning office, the zoning administrator takes them in and transmit them to the secretary of the Board of Zoning Appeals, or to the secretary or clerk of the Board of Supervisors, as the case may be. And that's the person who's in charge of doing the ad and all that stuff. Well, it then says that when the secretary of the BZA gets those applications, they're supposed to transmit it to the planning commission for such, and tell them when our hearing is going to be. We've had this discussion before, and tell them, here it is, if you want to make a recommendation, make it by the date of our meeting. And I don't see anything really in there that specifically says the planning commission has to have its own public hearing on special use or special exception permits. They have it.
Exception use.
What?
yes.
Right. They just have a meeting, and if they want to entertain public comment, they can do that, but so that other section, I don't know what the basis of that is, but certainly not in the state code, anything like that. I don't know where that came from. I know where it came from. It came from Fauquier, but
It may be a function of determining whether the application is complete or not, and I would only surmise.
But that's the job of either the BZA secretary or that we, in other words, they make recommendations. So we send it and say, here, we're going to have a hearing on this, like if it comes in, whatever, 16 days ahead of time or whatever, we send it over, it's supposed to come to me, and I'm supposed to send it to the chairman of the planning commission, say, put this on your agenda if you want to, I don't care if you do or not. But if you want to make a recommendation, you better make it by June 20th.
Does that have to be advertised, that hearing?
I don't think the planning commission has to have any public hearing, no.
So
I mean,
ultimately,
they have to have a public meeting, but they don't have to have a public hearing.
when I was on the planning commission agenda and I read the section to them and suggested they follow it, and oh, by the way, you're looking at the May amendments, you might want to look at this section.
It's already in the list.
Right.
I
So,
don't think that part of it, I'm not sure if that part of it.
so that was my recommendation to them. Is this really what you want to do? Now's the time when the ordinance
I don't
is
even think they can do that. I mean, the planning commission, they don't have anything to say, but they can make a recommendation, that's it. They don't. But over the years, and I don't really know how that happened, they've taken on they have a big public hearing, and they open and close the public hearing, and then somebody always makes a motion saying, I move that we approve this, and I'm always sitting over there saying, you mean you recommend that we approve it? We are the Board of Supervisors of the approving body, not the planning commission. They just make recommendations.
We've done a lot of work with Michelle's help, thank you, in tightening up and making checklists. And it may not be perfect just yet. And we move through the variances, the special exceptions, special use permits and so forth. So things are getting much tighter. So there should be less problem of an application not being 100% complete before it comes to some, before it hits someone's docket. So it's not perfect yet, and we're still moving forward.
It's a lot better.
But it's a lot better.
Yeah, it's getting
And
better.
so we're taking on the B&Bs and the air stuff and the tourist homes and so forth, and I think the next thing we need to take on is the signs.
Okay. Is that all we need? Is there a motion to adjourn?
Wait, he said.
I was just gonna say,
Oh, sorry.
in other localities I've been affiliated with, the special exceptions that went to the BZA showed up on
No,
the
Board of
plan
Supervisors.
in another locality. Okay.
They went to the BZA.
Yes.
Okay.
So all in a name, it doesn't matter
Okay.
what you call it, right?
To
They ended up on the planning commission agenda as a consent agenda item for information.
Right.
So it wasn't even,
They never have public.
Now,
It was just.
the locality also had conditional use permits that were decided by the board of
That's a different thing.
supervisors.
That's an
And that
amendment.
process very clearly codified,
But that's an amendment to the ordinance.
that's right, very clearly codified that there would be a public hearing in the planning commission and.
See, I'll tell you what the problem is. The problem is that the code section that is incorporated by reference into all of these other notice things, which is 15.2, 2204, it talks about advertising plans and amendments. And it's the general section that when you pass the zoning ordinance or the subdivision ordinance or the comp plan, you have to have a public hearing at the planning commission, and then you have to have a public hearing at the board of supervisors. But then, like our section on the BZA says, no variance will be granted or no special use will be granted unless they have a hearing or hearings. They have it in the plural, and that's the confusion because they're talking about all the permits, not all the bodies. They're talking about all the permits have to have hearings before, in accordance with 15.2, 2204. Well, somehow that got to where somebody decided the planning commission itself has to have a public hearing on special use permits. I just don't think that's not the way they do it other places, and I don't think that's really what it says. And if you look at the section, which is what 2310 I sent around today, it says about this approval of variances and special use permits. It says you get notice of the hearing in the singular to the neighbors and the adjoining landowners and all that. It doesn't say of the hearings, it says one. There's only supposed to be one hearing of the body that has the approval authority. So the only time you have public hearings at the planning commission are for zoning amendments or the original adoption of it.
I would say it's also clear, as we talked about the application from Mr. Fletcher, that timetable at 120 days from the public hearing is from the board, not the planning commission or anything like that. It's very clear in the ordinance that that's the case.
And I don't know where, is that in the state code? You have to check.
That's in local.
Yeah, but where did that come from? I mean, if
But
it's not in
the
the state.
state code says that the local code can put reasonable time on it.
Okay.
We don't know how we done it, we just done it.
You started to steal all my lines.
okay. Is that all?
That's all. I move to adjourn so that we can all get home and watch the Celtics.
Okay, is there a second?
I'll second it.
All in favor?
Okay, great.
And I'd like to thank